I'm Advocate Nikita Pandit and I will be giving an introduction to the intellectual property rights in India, and you're watching Legal Bytes. The main objective of this video is to understand what is intellectual property and which intellectual property rights are protected in India by the law. Intellectual property is anything that is created by the human mind. It includes art, inventions, names, symbols, music, movies, and so on. Creativity and invention are the main facets that help in the development of the nation. The development and growth in small industries, startups, movies, music, and the businesses like clothing brands, medicines, software have all enabled the protection to the pool of creative and inventive talent to a great extent. A good legislative framework and policies will only help us in promoting full economic and social exploitation of these intellectual property rights. It is when the artists and creators of these works are ensured of a protective environment for their creation, there will be motivation to create or invent new works. Intellectual properties are divided into two parts. First is copyright and other is industrial property. The rights which are given to the creators of literary works, artistic works, dramatic works, cinematographs are called copyrights. Copyright is given for the lifetime of the author and another 60 years after the death of the author. They also get the protection for their moral rights, which involve the right to be associated with their work, the right to protect their work from being destroyed, mutilated, and this is even after the transfer of the work. So moral rights are vested in the author even after they transfer the rights. Industrial properties, on the other hand, are divided into two parts. The first is where the protection is offered to the signs, symbols, names called the trademark rights, and another is where the protection is offered to inventions, innovations, or new technological development called patent rights. Trademarks are an identity of goods or services so that the public is not confused between the goods and services of different persons and enterprises, and they make an informed decision when they are purchasing or hiring the goods and services. Now, in case of patents, the right is in invention and technology. Now, this helps in promoting the science and development in the nation. So, the intellectual property rights give some exclusive rights to the rights holder. However, these rights are subject to some limitations and they are for a limited period of time. In India, some of the important recognized intellectual property rights are as follows. The first is copyright. Section 14 of Indian Copyrights Act 1957 gives the meaning of copyright. Copyright gives an exclusive right to the author of the works and are subject to the provisions of the Copyright Act in India, which was of 1957. These rights are in the works such as literary works, dramatic works, music, computer program, movies, and other artistic works. For example, the copyright subsists in books such as Pride and Prejudice, Fault in Our Stars, White Tiger, A Suitable Boy, or if you watch movies or series like Harry Potter, Fast and Furious, Game of Thrones, Big Bull, Sacred Games. Okay, so copyright is a transferable right. It is also assignable. Copyright consists bundle of rights. It provides right to the owner to reproduce their work, to distribute it, to sell it, to translate it, or adapt it in some another form. Indian Copyright Act provides protection to the work for the lifetime of the author and another 60 years after the death, as mentioned before. Copyrights Act of 1957 was amended in the year 2012 and it incorporated WIPO Copyrights Treaty and WIPO Performances and Phonograms Treaty in it. India is also a member to Berne Convention, which also protects the copyright at an international level. The second right is the trademark right. Trademark is an identity of the goods and services and it forms an important part of the trade. Trademarks help the owner of the trademark to govern how his brand and his name will be used. Trademark helps in distinguishing the goods and services of one enterprise or person from the other. Now this includes the brand, logo, packaging, shapes, and it is more appropriately mentioned in section 2ZB of the Trademarks Act of 1999. Section 2M clearly specifies what is a mark. It may include any symbol, brand, heading, label, words, letters, packing, colors, or combination of colors. Now as per section 25, the protection of the trademark is given for a period of 10 years, which can be renewed successively for 10 years each. The trademarks are governed by Indian Trademarks Act 1999 and the rules. India is also the follower of Madrid system for international protection of trademarks. Now some examples of Indian trademarks are Bata for shoes, Bajaj for electronics, Cartier for watches and perfumes, Bisleri for aqua mineral, Enfield Bullet for bikes, Honda for motors, Infosys in technology, and Kalpataru for properties. Third right is the patent right. Patent rights are given to the inventors of new inventions. These inventions are the new way of doing something which never existed before. Section 2L of the Patent Act of 1970 provides what are new inventions, and it is something that has never been anticipated or thought of before the date of patent application. Patent Act of 1970 governs the patents right, and it specifically mentions what cannot be patented. After 2002 amendment, the patent protection was given for a period of 20 years to the applicant. India follows Patent Cooperation Treaty and Paris Convention for international protection of the inventors and their patent rights. Patent rights have given a great impetus to the new startups in robotics, nanotechnologies, software, hardware, biotechnology, and pharmaceuticals. The fourth right is geographical indications. Geographical indication is a mark which represents the goods that originate or have the qualities that are attributed from being from a particular location. The characteristics and reputation of that product is because of being from that place. This right is usually enjoyed by multiple producers who have the right to use the mark and who belong to that area. The Indian law relating to geographical indications are included in Geographical Indications Act of 1999. Section 2E of the Act explains what are geographical indications. They are associated with the goods such as agricultural goods, manufactured goods, which are produced, processed, or prepared in a particular place, and they inherit the qualities of that product which is because of being from that place. The protection is given for a period of 10 years, which is renewable. Some of the recent Indian geographical indications are Gulbarga Tur Dal from Karnataka, Irish whiskey from Ireland, Gorakhpur terracotta from Uttar Pradesh, Kashmir saffron from Jammu and Kashmir. International protection is offered by Paris Convention of 1883 and by the TRIPS agreement. Now there are industrial designs. Design comprises of the look of the product. It is the aesthetic or ornamental characteristics of that product. Section 2D of Indian Designs Act 2000 mentions that design includes shape, sizes, colors, configuration, ornament in 2D or 3D form. The design is judged by an eye of the person. The registered owner of the designs have the exclusive right to use the design and prevent others from exploiting the same. The applicant gets the protection for a period of 10 years as a copyright for his design. Further, it can also be extended for 5 years. India does not follow the Hague Agreement for design protection but follows the international standards. Some examples of design are fashion, jewelry, cars, products, packages. Other important intellectual property are plant varieties, trade secrets and integrated circuits. So these are some important intellectual properties recognized by the law in India. Thank you.